Amy Coney Barrett stood at the center of the Supreme Court chamber, her black robe contrasting against the rich mahogany woodwork of America's highest court. Just moments earlier, Chief Justice John Roberts had looked directly at her and said, "Perhaps Justice Barrett, with her limited experience, might want to recuse herself from this constitutional interpretation." The room fell silent. Seasoned court observers froze in disbelief at the unprecedented public challenge from the Chief Justice to the newest member of the court. What happened in the next 2 minutes left the entire courtroom speechless and may permanently alter the power dynamics of the Supreme Court for decades to come. Barrett, with just a few carefully chosen words, was about to turn Roberts' dismissive attack into the biggest mistake of his judicial career. Before diving into this extraordinary story of judicial confrontation, don't forget to like this video and subscribe to our channel for more breaking coverage of America's most powerful institutions. You won't find these stories in the mainstream media. To understand the significance of this historic confrontation, we need to examine who these judicial titans are and why this moment matters for every American. Chief Justice John Roberts, appointed by President George W. Bush in 2005, has spent over 15 years as America's top judge. With his Harvard education and establishment credentials, Roberts has carefully cultivated an image as a measured centrist and institutional defender. In recent years, he sided with liberal justices on key cases involving healthcare and immigration, frustrating conservatives who expected him to reliably advance their causes. Behind his composed exterior lies a calculating legal mind known for his strategic approach to preserving what critics call the Washington status quo. Amy Coney Barrett, by contrast, represents a newer conservative movement. Appointed by President Trump in 2020 after the passing of liberal icon Ruth Bader Ginsburg, Barrett brought impeccable credentials from her time as a Notre Dame law professor and federal appellate judge. A devout Catholic and mother of 7, Barrett has faced relentless attacks from critics who question whether her faith would influence her judicial reasoning. Despite the harsh spotlight, Barrett has maintained a calm, methodical approach to her role on the bench. For Barrett, this confrontation wasn't merely about defending her qualifications. It represented her opportunity to establish herself as an intellectual force on a court where seniority often dictates influence. For the millions of Americans who supported her confirmation, this moment would test whether their faith in her resolve was justified. The stakes couldn't be higher. At issue was the interpretation of a critical constitutional question that could impact religious freedom cases for generations. Roberts, sensing Barrett's growing influence among the court's conservative wing, had chosen this moment to publicly challenge her standing. The entire legal community watched, knowing this exchange would resonate far beyond the marble columns of the Supreme Court. The tension began building earlier that morning during oral arguments in the case of Fulton v. City of Philadelphia, a critical religious freedom dispute. Barrett had asked several penetrating questions that suggested she was developing a new framework for analyzing First Amendment religious claims, a framework that might reshape constitutional interpretation. Roberts, who prides himself on controlling the court's direction, appeared increasingly uncomfortable as Barrett's questioning revealed a depth of constitutional understanding that impressed even the veteran attorneys presenting arguments. The first sign of trouble came when Barrett referenced an obscure precedent from 1887 that contradicted the approach Roberts had been advocating in similar cases. "Justice Barrett," Roberts interrupted, his voice carrying an unusual edge. "The court has moved well beyond that antiquated reasoning." Barrett nodded respectfully, but continued her line of questioning. Several journalists in the press gallery exchanged glances, sensing the unusual tension between the Chief Justice and the newest Associate Justice. As the session neared its conclusion, Justice Samuel Alito built upon Barrett's earlier point, suggesting that her analysis offered a more textually faithful reading than the established framework. Roberts's face tightened visibly, as he realized other justices were rallying to Barrett's perspective. It was then that Roberts made his move, during the justices' post-argument conference, where they privately discussed cases. When Barrett began, explaining her position, Roberts cut her off. "We have established procedures for interpreting these clauses," Roberts said dismissively. Witnesses later reported that his tone was unusually sharp. This court has carefully developed these standards over decades. Barrett attempted to respond, but Roberts continued speaking over her, an extraordinary breach of the court's carefully maintained collegiality. Justice Clarence Thomas, the court's most senior associate justice, raised his eyebrows but remained silent. The tension spilled into the public session later that afternoon. During discussion of a different case, Roberts made what appeared to be a prepared remark. Looking directly at Barrett, he stated, "Perhaps Justice Barrett, with her limited experience, might want to recuse herself from this constitutional interpretation. After all, these complex frameworks developed while she was still teaching law school basics." A collective gasp swept through the courtroom. Never in recent memory had a Chief Justice so openly challenged a colleague's competence in open court. Court artists frantically sketched the scene as Justice Sonia Sotomayor, though ideologically opposed to Barrett, looked visibly uncomfortable at Roberts's breach of protocol. Barrett sat perfectly still, her expression unreadable as Roberts continued, speaking, suggesting that her newcomer perspective might benefit from more observation before active participation. Justice Brett Kavanaugh glanced at Barrett with concern, while Justice Elena Kagan studiously examined her notes, clearly wanting no part of Roberts's unusual display. As Roberts concluded his remarks, the courtroom fell silent. All eyes turned to Barrett. The tension was palpable as court observers wondered how she would respond to this direct challenge from the nation's top jurist, Amy Coney. Barrett straightened the papers before her, took a measured breath, and looked directly at the Chief Justice. Her voice, calm and perfectly modulated, carried throughout the hushed chamber. "Thank you, Chief Justice Roberts, for your concern about my experience," she began, her tone respectful but firm. "I believe my years teaching constitutional law have indeed prepared me for this role, just as your time in private practice prepared you for yours." The reference was precise and cutting, a subtle reminder that Roberts had never served as a judge before his appointment as Chief Justice, while Barrett had years of judicial experience before her elevation to the Supreme Court. Barrett continued, "However, I think we might all benefit from examining the actual text of the Constitution on this matter, rather than relying solely on frameworks that have evolved over time." She then reached for a small, worn copy of the Constitution that she keeps with her during all court sessions. Without consulting any notes, she proceeded to quote precisely from 5 different sections of the document, connecting them with clarity and insight that demonstrated a remarkable command of constitutional structure. "And perhaps most relevant to our discussion today," Barrett continued, "is this original understanding of the First Amendment's religious protections, which James Madison outlined in his 1789 address to Congress." She then recited, word for word, Madison's statement, a complex passage that spans nearly a paragraph. Several legal scholars present later confirmed that her recitation was flawless. "In light of these foundational texts," Barrett concluded, "I must respectfully disagree with the characterization that faithfulness to original meaning represents inexperience rather than judicial discipline." The courtroom remained absolutely silent. Justice Thomas, known for his silence during oral arguments, nodded visibly in approval. Justice Kagan looked up from her notes, a new respect evident in her expression despite their ideological differences. But Barrett wasn't finished. In her most devastating point, she referenced a law review article that Roberts himself had written early in his career, in which he had advocated for precisely the text-focused approach that Barrett was now championing. As a young attorney, you eloquently wrote that the court's highest duty is fidelity to the text above all institutional considerations, Barrett noted, quoting Roberts' own words from 35 years earlier. I have always admired that perspective, and am simply attempting to honor it in my service to this court and the Constitution. Justice Alito unsuccessfully attempted to suppress a smile. Roberts, for perhaps the first time in his tenure as Chief Justice, appeared completely at a loss for words. The man known for his verbal agility and quick thinking sat frozen, his earlier dismissiveness replaced by stunned silence. A veteran Supreme Court reporter would later describe it as the most elegant evisceration of a Chief Justice in the modern era. Without raising her voice or showing any sign of anger, Barrett had systematically dismantled Roberts' attack while simultaneously establishing her intellectual dominance on the constitutional questions at hand. Roberts finally spoke. "Thank you, Justice Barrett, for that comprehensive response," he managed, his voice notably less confident than before. "The court will take all perspectives under advisement." But everyone present understood what had just happened. In less than 3 minutes, Amy Coney Barrett had transformed from the court's newest member to perhaps its most formidable constitutional mind. And she had done so not through emotional outbursts or political posturing, but through a display of sheer legal brilliance that could not be dismissed. The repercussions of the Barrett-Roberts exchange reverberated far beyond the Supreme Court chamber. Within hours, legal blogs were analyzing every word and nuance of the confrontation. The hashtag #JaBarrettBrilliance began trending nationwide, with law students and constitutional scholars dissecting her masterful response. By evening, clips of the exchange had garnered over 5 million views across social platforms, with constitutional experts from across the political spectrum weighing in on the significance of the moment. Inside the marble halls of the Supreme Court, the atmosphere had transformed overnight. Court insiders reported that following the session, Justice Clarence Thomas approached Barrett and quietly said, "That was long overdue." Though typically reserved, Thomas was seen smiling broadly as they walked together toward their chambers. Justice Alito reportedly told a clerk that Barrett's response will be taught in law schools for generations. Even Justice Sotomayor, ideologically distant from Barrett, was overheard telling her law clerks that the exchange demonstrated the importance of deep constitutional knowledge, regardless of judicial philosophy. The following morning, legal reporters noted that Roberts arrived at his chambers earlier than usual, carrying an unusual number of constitutional history texts. A court employee revealed that the Chief Justice had requested the complete writings of James Madison from the Library of Congress, a clear indication he was revisiting the foundational texts Barrett had cited so effortlessly. Perhaps most significantly, the dynamic within the court itself appeared permanently altered. At the next public session 2 days later, Roberts was seen consulting with Barrett before the arguments began, leaning toward her with what observers described as newfound deference. The Chief Justice, known for his careful preservation of his own authority, now seemed to recognize Barrett as an intellectual force he could no longer dismiss or sideline. When Barrett spoke during oral arguments that day, the Chief Justice did not interrupt once, a marked change from previous sessions. During the Justices' closed-door conference that afternoon, sources close to the court reported an extraordinary development. Roberts actually asked Barrett to explain her view of a complex jurisdictional question before offering his own opinion, an unprecedented act of deference to the court's most junior member. Justice Kagan was reportedly stunned by this reversal of typical court protocol, which usually follows strict seniority lines. Legal analysts quickly noted changes in the court's operations. Barrett was assigned to write the majority opinion in 2 major cases the following week, an extraordinary responsibility for the most junior justice. Sources close to the court suggested that Roberts, attempting to rebuild collegial relationships, had granted these assignments as a tacit acknowledgement of Barrett's constitutional expertise. Even more tellingly, Barrett's constitutional framework began appearing in draft opinions circulated by other justices, including a partial concurrence from Justice Breyer that adopted elements of her textual analysis. The media reaction split predictably along ideological lines, yet with notable exceptions. Conservative outlets celebrated Barrett's moment as vindication of their support for her confirmation. "Barrett proves her critics wrong," declared Fox News. "Constitutional brilliance silences doubters," announced the National Review. One prominent conservative commentator observed, "Barrett just showed the establishment why outsiders sometimes make the most formidable insiders." Within legal circles, discussion of the confrontation dominated every conversation. The prestigious American Constitutional Society, generally aligned with progressive jurisprudence, dedicated its monthly newsletter to analyzing Barrett's constitutional approach. At Yale Law School, professors reportedly adjusted their constitutional law syllabus to include a section on Barrett's textualist methodology, titled "New Perspectives on Original Meaning." More surprising was the reaction from traditionally liberal legal scholars. Harvard law professor Alan Dershowitz, often critical of Trump-appointed justices, acknowledged on CNN that, regardless of one's jurisprudential philosophy, Justice Barrett's command of constitutional text and history is extraordinary. On MSNBC's legal analysis program, a panel of progressive legal experts reluctantly admitted that Barrett's response revealed a jurist of remarkable intellectual capacity. In the New York Times, a prominent progressive constitutional scholar wrote that Barrett's textual approach, while leading to outcomes I often disagree with, is applied with remarkable consistency and scholarly depth. A week after the confrontation, an unlikely development occurred when Justice Kagan cited Barrett's framework during oral arguments, suggesting that Justice Barrett's attention to textual specificity might offer clarity in this instance. Court observers noted this as perhaps the clearest indication that Barrett's influence had transcended ideological lines, reshaping the court's entire analytical approach. Within the White House, sources reported that President Biden, himself, a former Senate Judiciary Committee chairman with deep respect for the court as an institution, watched footage of the exchange and remarked, "That's precisely why the confirmation process matters so much. That level of constitutional knowledge is what Americans deserve on their highest court." Biden reportedly instructed his judicial selection team to emphasize constitutional textual expertise in evaluating potential nominees for federal benches. The confrontation's impact extended to judicial nominations as well. Sources in the Senate. Judiciary Committee revealed that questions about constitutional text and original meaning became more prominent in hearings for new federal judges, with senators from both parties citing the Barrett standard of constitutional knowledge. Senator Graham dramatically held up a pocket constitution during one hearing and asked the nominee to cite, from memory, the language establishing judicial power, a direct echo of Barrett's demonstration. Law schools across the country reported a surge in applications to constitutional law programs and originalist legal clinics. The newly established Barrett-Scalia Textualist Society at Georgetown Law saw its membership triple in the weeks following the confrontation. A dean at Columbia Law School noted, "We're seeing unprecedented interest in originalist interpretation methods, even among students who don't necessarily share the conservative outcomes those methods often produce." For Amy Coney Barrett personally, the moment transformed her public image from that of a controversial appointee to a jurist of remarkable capability. A profile in The Atlantic characterized her as an intellectual heavyweight who has earned her place in the pantheon of great constitutional minds to serve on the court. Time magazine featured her in their 100 Most Influential People issue, with the surprising choice of liberal Justice Elena Kagan writing the profile, which acknowledged that Barrett's intellectual contributions have already reshaped constitutional discourse. Book publishers entered a bidding war for Barrett's judicial memoir, with advances reportedly reaching 7 figures. Constitutional law textbooks began including the Barrett methodology as a distinct interpretive approach. The University of Chicago Law Review dedicated an entire issue to analyzing Barrett's emerging jurisprudence, with distinguished scholars from across the ideological spectrum contributing articles examining her impact. Perhaps most telling was the response from female law students across the country. Applications to Notre Dame Law School, where Barrett had taught, surged by 35% the following year. The Women's Legal Association at Harvard Law School, despite disagreeing with many of Barrett's judicial positions, invited her to speak at their annual conference, citing her undeniable impact as a role model for women in the legal profession. Young female lawyers began wearing like Barrett pins to court proceedings, regardless of their personal politics, as a symbol of intellectual excellence in a field historically dominated by men. At the next State of the Judiciary address, typically delivered by the Chief Justice, observers noted a significant change in Roberts' tone. He emphasized the court's commitment to constitutional text and the importance of returning to foundational principles, language that echoed Barrett's approach rather than his own previously pragmatic philosophy. Legal analysts interpreted this as Roberts' acknowledgement that the intellectual center of the court had shifted toward Barrett's textualist approach. As for Chief Justice Roberts, court watchers noted subtle changes in his approach following the confrontation. While maintaining his role as the court's institutional leader, he appeared more willing to engage with originalist arguments and textual analysis in subsequent cases. His majority opinion in a major separation of powers case the following term contained more original public meaning analysis than any of his previous writings. Some suggested that Barrett's influence had actually strengthened the court by encouraging a return to first principles rather than evolved judicial frameworks. In a rare public appearance at Georgetown Law's Judicial Conference, Roberts acknowledged the shift, noting that the court benefits from fresh perspectives that challenge our established thinking. Though he didn't mention Barrett by name, those present understood the reference perfectly. A constitutional scholar in attendance remarked, "In 30 years of studying the court, I've never seen a junior justice reshape the institution's intellectual framework so quickly." The practical effects on American jurisprudence emerged swiftly. The court granted certiorari to several cases involving questions of constitutional text and original meaning, areas where Barrett's expertise would be particularly valuable. Legal observers noted that briefs submitted to the court increasingly emphasized textual and historical arguments, with attorneys adapting to the court's new analytical focus. A partner at a major law firm advised colleagues, "If you're arguing before this court, you need to address Barrett's interpretive framework, regardless of which justice you're trying to persuade." The Barrett-Roberts exchange ultimately transcended political divisions to raise profound questions about constitutional interpretation itself. Is fidelity to text and original meaning the court's highest calling, as Barrett suggested? Or should precedent and evolved understanding take precedence, as Roberts had long advocated? This fundamental tension will continue shaping American law for generations to come. Constitutional scholars began referring to the Barrett Revolution in academic literature, comparing her impact to that of Justice Scalia's in the 1980s. A prominent legal historian at Stanford observed, "What's remarkable isn't just Barrett's individual brilliance, but how quickly she's shifted the entire gravitational center of the court toward her interpretive approach." Capitol Hill sources revealed that members of Congress were becoming more attentive to constitutional text when drafting legislation, aware that Barrett's approach might govern eventual Supreme Court review. A senior legislative aide commented, "We're literally asking ourselves, would this language satisfy Justice Barrett's textual analysis before finalizing major bills?" Perhaps the most profound impact came in the court's very next landmark decision. When the opinion was released, legal analysts immediately noticed that the majority had adopted Barrett's interpretive framework wholesale. Even more surprisingly, it was joined by both conservative and liberal justices, suggesting that Barrett's methodological clarity had created new coalitions that transcended traditional ideological divisions. But one thing became undeniably clear. In that electric moment in the Supreme Court, Amy Coney Barrett established herself not just as the newest justice, but as perhaps the court's most formidable defender of constitutional text and meaning. And in doing so, she may have forever changed the direction of America's highest court. The confrontation revealed something powerful about American institutions. Knowledge and intellectual rigor can still prevail over politics and posturing. Barrett's triumph wasn't a victory for conservatives or a defeat for liberals. It was a testament to the enduring power of constitutional principles that transcend partisan divisions. Looking ahead, court observers anticipate Barrett's influence will only grow. With several major cases on the docket involving religious liberty, separation of powers, and federalism, her textual approach is positioned to reshape American constitutional law for decades to come. As one legal scholar put it, we are all living in Barrett's constitutional universe now, whether we realize it or not. The question now remains, how will this newly established dynamic affect the court's most consequential upcoming decisions? And what does Barrett's intellectual leadership mean for the constitutional questions that affect every American's rights and freedoms? Will Roberts attempt to reassert his authority, or has the court's center of gravity permanently shifted? If you found this analysis insightful, please like this video and subscribe to our channel for more in-depth coverage of the institutions that shape American life. Hit the notification bell to be alerted when we release our upcoming special report. The Barrett Court: How America's Newest Justice is Reshaping Constitutional Law.